Tonight, we are honored, really truly honored, to have media law experts Ben Birkenbein and Patrick Feil from the Reynolds School of Journalism as our guest. Ben holds a PhD in media studies, an MA in media theory and research, and a BA in communication, and his research is rooted in the political economy of communication. Patrick holds a PhD and master's in journalism and mass communication, and his research in media and law and history is published in several journals, including the Journal of Media Law and Ethics. Thank you both for being here. We really do appreciate you giving up your time this evening. I will go ahead and pose the first question, allow you both to answer and encourage others to chime in from there. First, with your backgrounds, I personally am really interested to hear what was going through your minds as we watch social network after social network ban former President Trump from their platforms, and how and when you thought the First Amendment came into play.
Is that a cue to me, Ben?
Go ahead, yeah, go ahead, take the first one.
I mean, obviously my first thought was like, well, I'm going to be doing a lot of these kinds of events, I think, doing a lot of talking about where the First Amendment does and doesn't get involved was one of my first thoughts. I'd say another thought that I had about it was that this is going to be somewhat of a simpler answer than I think a lot of folks might otherwise think. There is what I would call, and that's a good thing, because it's rooted in what I would call a kind of free speech culture that we have in the country. That means that a lot of we kind of view the world or view democratic engagement in the country as really sort of protected and driven by freedom of speech kind of anywhere and everywhere all the time, even when the First Amendment wouldn't necessarily have anything to do with it. The simple part of the answer is that social media companies aren't obliged under the First Amendment to give a platform to anybody, any user, no matter who they are. And the First Amendment doesn't come into play here because the government doesn't. This isn't the government stepping in and banning Trump or any other user from using that platform. The First Amendment operates under what's known as the state action doctrine. And so basically the First Amendment and First Amendment rights are triggered when the government tries to infringe or sanction someone's speech, or indeed force someone to speak. And so that's not what's happening here. And so the answer is pretty simple, which is, Trump doesn't have a First Amendment right, nor does anybody else, to use Twitter, and the First Amendment doesn't sort of force Twitter to allow people like Trump or others to have a platform. But like I say, I think sometimes the fact that the question arises has to do often with the fact that we have expectations culturally that people have lots of opportunities to speak freely, and that the kind of any form of limitation on that offends the First Amendment, or at least offends our cultural appreciation for freedom of speech.
Yeah, it looks like Donna is sharing a screen. Is that right? Patrick, were you done with your thought there?
Yeah, over to you, Professor Birkenbein.
All right, very good. Yeah, I also had a similar thought. I was actually preparing my materials for teaching a winter course on the First Amendment. So immediately I started just thinking about a very nice case study, or that may in fact be simpler, as Patrick put it, because one of the things that we do whenever we're talking about any question of the First Amendment is I often tell my students to start making the very important distinctions that need to be made between whether or not we are actually dealing with a government restriction, like a Congress making any law that's going to infringe on someone's rights to free speech, versus a private company. And in fact, we've seen, that private companies basically thrive on controversy and attention and engagement with their platforms. And certainly, Facebook and Twitter are right there. And as Patrick said, they really have broad discretion as a privately owned company, or as a private company, to regulate their platforms in whatever way they want. There's a more complicated kind of answer to all of that, which is that to look historically at the social media companies, because they seem to have wanted it both ways. They've always been saying that they support the First Amendment and that they want to be treated as some sort of public forum, and that they refused to crack down on any sort of speech or falsehoods, et cetera, within reason, of course. I mean, there have been materials taken down, and yet they sort of hid behind that while also hiding behind another regulation, which comes from the Telecommunications Act of 1996, which is Section 230 of the CDA, and which basically provides immunity from internet service providers from any content that's posted to their site that's provided by another provider. So basically that means that the company, the platform, is not responsible for the content of the speech of anyone else who posts to that platform. So they sort of have shielded themselves from lots of either legal action or kind of broader ethical controversies by simply shielding themselves behind these two things, both wanting the First Amendment while also saying, no, we're a private company and we're an ISP, so we're not liable for anything that takes place on our platform. So anyway, so I'll leave it at that and we can spin off of that, I guess, if we want to.
Molly, go ahead.
Hi, can you guys hear me okay? My internet's been weird. Perfect. So for me, now this kind of raises the question, has mostly Twitter really given itself like an ethical standard that from here on out, they're going to be banning people that are quote unquote inciting violence or that aren't following along with an established status quo and potentially creating themselves to be the dictators of what that status quo could be. Do you think that's going to be like a trend moving forward, or that, you know, they've created this slippery slope and like, where's that going to lead?
Yeah, maybe I'll start with this one as well, which is basically, yes, I think that it is. And I think that other companies like Google, most notably, and other researchers who have been doing work on large tech companies have simply pointed to their own policy descriptions and the failure of the company to seemingly live up to their own policies or apply those policies in a somewhat arbitrary manner, right? So certainly they will be getting a lot of heat for what their policy is going to be if they are going to adopt an official policy which says these are the acceptable uses of our platform, or if they're not going to identify their policy and then, as you say, just sort of arbitrarily enforce it on whatever types of content that they deem to be inappropriate for the platform. So I think that right now, particularly after the events that took place at the Capitol, I think there's a heightened sort of public awareness of trying to combat the spread of either disinformation, misinformation, et cetera, or any sort of incitement or inciting speech. And yet, you know, again, we keep going back to the fact that we're sort of relying on, you know, private companies to enforce this for us, whereas there's not really a regulation or policy to do this otherwise. We can talk about sort of some court cases that might be used to determine whether speech did incite a riot. There's precedent for that, but we have now arrived at a sort of historical moment when, like it or not, I mean, these platforms they do kind of serve this purpose of being somewhat of a public forum, even though they may not be designated as one, you know, under the law. It's that people do get a lot of their information from these platforms, and the platforms continue to eat up a lot of advertising dollars, et cetera, et cetera. So the broader kind of commercial foundations of the platforms are really what has led to where we are today because of the need for engagement, et cetera, et cetera. So.
Yeah, I think I don't have a whole lot to add to that. I mean, I think sort of back to the original question there, I think that, you know, if I was an attorney for Twitter, what I'd probably be saying is that, you know, this was kind of a narrow set of circumstances and that, you know, we weren't sort of setting a precedent here. So there is no slippery slope, that there was, you know, an actual insurrection that took place. And so that's a pretty easy call for us to say, you know, we're kind of continuing to foment that type of violence is something that we don't have to tolerate. And we're, you know, is clearly outside of the bounds of what we do have to tolerate. And I think as Ben was saying, that some of the subsequent booting of people off of at least Twitter, and I think a couple of other platforms, has been mostly related to kind of misinformation around the election and whether or not that's whether basically it was a free and fair election. And so I think they've kind of drawn that box and said, okay, that's, right now that's where we're going to kind of be drawing the line. But, as I think you rightly point out, where circumstances different, where facts a little bit different, it's a little difficult to see how a company holds to that standard and says, no, we're being consistent here, and this is an appropriate use of the kind of awesome power of the ban that we have to this platform that's a conduit to millions and millions of people.
Great question. Ira?
So if we were talking about broadcast, television or cable, the FCC oversees that, and they have certain guidelines and things that this would fall under. Is there anything like that for the internet? I mean, there's always that joke about who owns the internet, but is there any government regulation whatsoever of the internet itself?
Yeah, go ahead, Patrick.
Oh, well, so, I mean, not nearly as much as there is on broadcast. And the case that you look at to kind of understand that, that I put in front of my students is Red Lion v. FCC, which is a 1969 case, I think, that dealt with the limitations that the FCC was imposing on political speech and actually gives justification for the fairness doctrine, which was then subsequently done away with in the 1980s. And then finally, in I think 2008, the Obama FCC wrote it out of the statute books formally. The reason I have my students read that old case in part is because it explains the justification for why the FCC has the power that it has to regulate broadcast media, i.e. broadcast television, broadcast radio, not including, at least not to the sort of level of content restriction that they place. So broadcast television, radio can be regulated fairly heavily for content. Cable television, satellite radio, things like that can't be. And the justification for that is that it is a finite public resource that is broadcast, the broadcast spectrum. So there can only be so many people using that spectrum at a given time in a given geographic area. And so like other natural resources, you have to limit who can have access to it, when and where and how. The Communications Decency Act, I think we'll talk about that a little bit, probably that'll come up and we'll talk about that a little bit more. That was part of a suite of kind of sweeping changes to the law in 1996 that Ben already mentioned, that put in place a whole bunch of content regulations specifically related to pornography and sexually oriented content, and essentially said that anybody who knowingly allows that type of content to reach children could be criminally prosecuted under the law. In a 1998 case, ACLU versus Reno, Janet Reno, not the city of Reno, that most of that law was struck down because the court essentially looked at it through the lens of Red Lion and said, there's not this limited spectrum online. The part of the benefit of the internet is that it's unlimited. And so as a consequence of that, we can't use this sort of limited spectrum scarcity argument to regulate, and Congress can't regulate content on the internet. And so that was part of, so that is part of, I think, the answer to your question, which is sort of why there isn't sort of sweeping and broad regulation of content on the internet, because where you don't have limitations on who can use it and when they can use it and how much they can use it, then it is much more a kind of wide open public forum for speech rather than a heavily government regulated natural resource. I hope that sort of answers the question.
I was just going to say nothing really more to add. The simple answer is no, and it's specifically, am I muted? Okay. It's specifically because of Section 230 of the Communications Decency Act, which people have kind of hid behind. So you've got this kind of Wild West frontier, which is actually in the roots of the internet itself. I mean, one of the other foundational documents that was written at the time, just shortly after the internet was privatized, or at least internet access was privatized in 1994, was the Declaration of rights. What is it? It's the John Perry Barlow, the lyricist for the Grateful Dead. It was a Declaration for the Independence of the Rights of Cyberspace or something like that, which is one of the foundational documents of this like cyber libertarian movement, which is that the governments have no place here, you know, in this internet that we call home. And we're going to continue to fight for that freedom to police ourselves in the ways that we deem fit. So some of those principles are still very much, you know, at play there online.
Okay, our next question is from Jackie. You're on mute, Jackie.
Sorry. So Twitter has their rules and they enforce their rules, except for they haven't enforced their rules with Trump in 4 years, because it's not like this just started. And then you have a platform like Parler that seems to, until they got taken off the air, encourage this kind of behavior. Isn't there some kind of responsibility or law? Could they be held liable if something bad had happened based on some conspiracy theory that had started there because they weren't policing themselves?
I mean, the short answer is no. And that gets us back to Section 230 of the Communications Decency Act that Ben was talking about. I think the reason, and I think there's some history that's worth knowing about why this law was passed in the first place, why it came to be. Basically, there are a couple of reasons. One is that there were conflicting court rulings through the mid-1990s around whether platforms, whether websites could or should be held liable for the speech of their users. And what was interesting was you had this kind of backwards logic that was driving the way some of these court decisions, or at least as Congress saw it, was backwards logic that was driving some of these court decisions, wherein you had a company called CompuServe, which you might remember, offered a suite of sort of internet-related products and internet access-related things like listservs and web browsers and things like that. You had another company, Prodigy. And the way that these two worked was quite different. CompuServe said, we're going to give you kind of the good, the bad, the ugly, all of the internet. You can go here, and kind of have full unfettered access to the internet. Prodigy said, we're going to be a little bit more family friendly. And so what we're going to do is kind of carefully curate the internet that you get. And so, for example, we can tell you that we're going to do our best to keep, pornography away from your children and things like that. So inevitably, some of that objectionable material gets through the Prodigy filters, and Prodigy gets sued. And they say, listen, you told us you weren't going to offer this, that you were going to offer a service that was family friendly, and you're failing to do that. And they lost that case. And so we were at a point where some court rulings were setting up the possibility where you had internet companies, internet providers, service providers that were going to be discouraged from doing any kind of filtering or any kind of moderating, because if they did that, they'd be civilly liable for doing so. And so what the Communications Decency Act, it's kind of thumbnail name, its sort of nickname was the Good Samaritan provision of the Communications Decency Act, because it was meant to encourage platforms to moderate by limiting their liability for basically tortious speech, right? Things like libel, invasion of privacy, other forms of sort of, civil liability triggering misinformation, things like that, fraud. Of course, criminal laws still apply if if your platform is allowing people to engage in human trafficking or other kinds of things that are illegal, then you don't have the shield of the Communications Decency Act. And so that's a roundabout way of, I think, kind of explaining a little bit of why the Communications Decency Act exists. I don't know, maybe Ben, you can pick up the thread from kind of like how it's played out since and what, maybe people's criticisms of it now are. But I think it's useful to kind of understand some of that background about why it exists and why, it's such a strong kind of bulwark that allows a lot of these websites to, allow their users to engage in all the kinds of hate speech and harassment and tortious activity that they do.
Yeah, in fact, I would just add that So number one, it's a really good coverage of the kind of Communications Decency Act, where that came from. And I would point out that if people have been reading the news, there is a movement afoot to revisit the provisions of the Communications Act, and specifically Section 230. And there's actually relatively bipartisan support for that, but for very different reasons. So I'll be very curious to see what happens with this sort of budding movement to revisit Section 230 to specifically allow greater policing of content online. That's the first part I would say. The second part is, which may get to the original question a little bit too, is remember that one of the principles at the heart of the First Amendment is that we tend to allow speech to happen and then punish it afterwards if we can provide evidence that a crime has been committed or some sort of conspiracy. But what we don't really allow for is the censorship, is the prior restraint on speech, right? So typically we allow people to say whatever they want. And then if we can use that as evidence to point to some sort of conspiracy or something else, we can subsequently punish that after the speech has occurred. But speech itself is very difficult to charge someone with, but it just provides one other source of evidence in an ongoing investigation for other sorts of activities. So when you move from the realm of speech to conduct, then you can police conduct much easier than you can police speech. And so that's one of the other things that we often discuss too in the class is like what qualifies as speech, what qualifies as conduct. Even things like interpretive dance or sculptures or paintings, right? Is it speech or is it conduct? Burning the flag, burning a draft card. All of these are kind of classic cases related to the First Amendment and for what purposes those activities are engaged in.
Do you believe the lines are blurred a little now if, let's say, there was a lawsuit either involving what happened at the Capitol or Trump decides to go against Twitter, where his past tweets may have proven evidence to what happened at the Capitol, but he has an argument. Does he have an argument that Twitter then deleted those tweets and took him and prevented him from using it as a platform to talk to people? Do you think there's some sort of blurred lines or any accountabilities there?
Maybe I'll start with this one. I'll just say that we have a case that is used to determine whether or not speech will lead to imminent lawless action. So there's the imminent lawless action test that comes from Brandenburg versus Ohio, 1964. Maybe Patrick and I can proofread dates 69. For each other, but I'm pretty sure it's 1964. Which basically says that you can look at the context or the content of a speech, and then you apply a test to determine whether or not that speech was responsible or would be responsible for imminent lawless action. So it's the intent of the speech. What was the intent of the speaker? What is the likelihood that these events would take place? So if Trump says, we need to go march on the Capitol and destroy it or something, and then they do, and then what's the likelihood that it will take place? Did I say that? Intent, imminence, and likelihood. So what's the likelihood it takes place, and how soon will it happen? So to your point, could you go back and historically look at all of the archive of Trump's tweets and try to connect those with activities that have taken place? You could try, but again, I would say that there's probably a defense to be made in defending that type of speech as abstract advocacy and not necessarily a specified threat being made on someone's life or something else. So that's another distinction to be made when we're talking about the content of speech and whether or not it can be punished, so to speak.
Yeah, I think so. Just to kind of add to that, I think a couple of things. I mean, the Brandenburg case is an issue here. I mean, in fact, I was talking with a colleague, about sort of in the days following. I don't know if I'm getting chopped up a little bit. I'm seeing some lag in the other screens, but okay, I'm seeing maybe I'm all right. I was talking with a colleague about the fact that for many of us, literally the way we talk about what incitement is kind of what would be the case that would that would rise to the level of prosecution. prosecutable incitement. It's like, well, if you got someone standing, right by the Capitol, and you got this, a crowd that's, really fired up and maybe carrying weapons, and you say, there's the Capitol, go in there and go get them. Which, when you parse through Trump's speech before the Stop the Steal rally on the 6th of January, was right up to that line. Of course, these are always very fact specific, but I mean, you look at that and you're like, that's the example we use. And so, the likelihood, it'll be interesting to see. I've got some further thoughts about the likelihood of a criminal prosecution of Trump for incitement. I mean, as we know, the single charge of impeachment that for the ongoing impeachment is incitement to insurrection. And what we also know, hopefully, about impeachment trials is that they're not criminal; they're a political trial, and so there's not a requirement in that case that in impeachment that the senators show that he actually met the criminal standard for incitement. Nevertheless, I think we'll be parsing through a little bit of what was said, and what it precipitated and what followed. And so we'll kind of have a, I'd say kind of unfortunately, a sort of political discussion about a criminal concept, which is, that incitement. The only other thing I guess I wanted to mention about the Brandenburg case was that, it is what Brandenburg did in 1969. Obviously, it wasn't the first time that the court looked at and tried to answer a question of like, what kind of speech is so dangerous that it should be criminally prosecuted or even prevented, and therefore isn't protected by the First Amendment. And the standard that the courts had been using for decades since World War I was the clear and present danger test. I think a lot of folks have probably heard that phrase. Oh, it's a clear and present danger to the nation, or within that case was the sort of infamous phrase of you can't falsely shout fire in a crowded theater, which also gets trotted out as a trope, as a sort of like, well, that's the limit we can place on freedom of speech. And the problem, I'd say, or I guess the problem that was solved with the Brandenburg case was one of sort of how a court analyzes sort of how far is too far. And clear and present danger sort of had a lot to do with sort of feeling. The court had to kind of feel its way to the sort of, whether what someone was saying was going to cause some sort of harm to the country or to individuals or anything along those lines. Brandenburg is more of an evidence-based test, right? How likely is the harm to be? Is it intended to come about? And is it imminent, right? Those three factors are really evidence that you can sort of trot out in a trial and say, okay, yes, indeed, it was imminent. Yes, indeed, it was intended by the speaker to take place. And of course, it was likely to take place as well. And so it kind of closed up that standard. I think the challenge is, and I think maybe getting back to some of what Sarah was asking, is that, we're also, in 1969, we didn't even have cable television yet, let alone social media and instantaneous access to kind of all things happening everywhere all the time. And so what courts haven't really gotten into sort of digging into a lot is, how those kind of standards of evidence about imminence and likelihood and intent are affected when people are, either sitting at a computer or standing in a crowd, in front of the Capitol, or I guess in front of the White House, in the case of the Trump speech. So I think that's, I think that, again, maybe a little bit of additional context to sort of help us think through some of these things.
Thank you. I have a submitted question to read. Can social media platforms draw a parallel between protections for businesses who don't want to bake a cake for a gay wedding, religious beliefs, and social platforms who don't want to share certain content?
I mean, so I don't have a good answer for this. What I can say is that the Masterpiece Cake Shop case, and then I think the court's about to hear another sort of religious liberty case that deals certainly with the First Amendment right, but more along the religion clause. It's a little early yet to say kind of how this fits into the other clauses, the other, ability of other companies to make decisions about, who they do or don't give a platform to. other than to say that those are sort of distinct rights with distinct doctrine under the First Amendment and through the U.S. justice system, or I guess the judicial system, I think it's a little early to say kind of whether there's a direct line that can be drawn between those two things. We're talking about sort of a religious right versus a commercial right. I guess the one other thing I would say is it does raise an interesting question, because where we see, two things we can say about the current formulation of the U.S. Supreme Court, or at least as it's been the last 6 to 10 years or so, is that they've been supportive of religious liberty rights. That's kind of a big part of the First Amendment that they have been sort of solicitous of. And then they've also been very protective of corporate free speech rights. And so you would expect the U.S. Supreme Court to kind of be supportive of an interpretation of the First Amendment that allows Twitter to have expansive authority to decide who gets to use their platform and who doesn't, and things like that. And those things obviously are somewhat in concert, but I don't know if they kind of line up, or we can sort of draw a straight line between those two things, or that the court would.
Yeah, it's excellently said. In fact, usually I've gotten like somewhat similar questions sometimes in class, and it's oftentimes maybe unsatisfactory to give a response with like, it depends, but we are still starting to see kind of what you start to get used to is like, you have Supreme Court decisions which establish precedent, and then we kind of know where the lines are drawn in those cases. But then there's other things where, as Patrick pointed to, there's sort of the makeup of the court, how it seems like they're interpreting certain things, and then these broader historical trajectories toward greater rights for corporations by way of free speech, greater protection of religious liberty in various cases, et cetera, et cetera. And you can kind of look at those trends and start to say, you can see like where things are working their way through the federal court system, like the kind of activism that's involved with trying to get something before the court to get a case there. But yeah, it really depends on how things are going to work themselves out along these lines.
Okay, our next question comes from Sierra.
Hi. Hi, Patrick. It's good to see you.
Good to see you too.
So we see, I feel like I don't really know how to word this question, but we see a lot of people getting their news from social media, and having social media being a private entity where they are allowed to ban and everything, take people off. Do you see the like maybe the jargon that they have in their agreements are going to change at all in the future because of this?
Sort
I'm
of
not
like,
sure.
Sorry, just to clarify, you mean like jargon in their agreements related to like the content or the news, or like what?
Yeah, well, so Patrick said in the beginning, they can ban Trump from being on social media because it is a private entity. It's not a government. So they're not inflicting on anyone's freedom of speech, because the First Amendment, correct me if I'm wrong, is the government cannot tell you not to say something, because that's taking away your right of freedom of speech. But Twitter can say you can't say that because they're a private entity. But because so many people are using the platforms more as a way to, like, especially Twitter, to keep up with the news, do you see either Twitter like having to hash out a new type of agreement, or do you see like the news just not living on there anymore?
Well,
Did that clarify better?
Yeah, I mean, I guess I can sort of take a stab at it, and then we'll see if I get close or anything like that. But I think you're right. I don't see news or discussion of news ceasing to kind of take place on Twitter, or especially in that regard. But to my ears, this sounds sort of like a broader kind of economic point. So given that my interest in political economy, I would say, if you look at the way that these platforms have kind of sucked up advertising dollars, which basically takes away from local journalists, or you get the original journalism that's posted on those sites and then consumed, and yet the advertising dollars never reach the local journalists. So there's a broader structural question about support for journalism and the continuation of the institution of journalism to try to dispel myths and to try to continue to tell the truth in the face of kind of swirling and circulating misinformation or commentary or other sort of perspective that's taking place on the social media networks. So the extent to which Facebook or Twitter wants to crack down on a discussion of the news, again, is directly undercutting their own economic interests to a certain degree. And that's a difficult proposition to put before the social media companies, to say that, like, yes, we get it. You rely on people circulating news and discussing the news and debating and arguing on your platform. And yet we're going to ask you that now to just like cut off speech that may be going too far about it. They don't want to do that because they have an economic incentive not to do it, to just allow people to go crazy and continue to talk with each other, because that's what their business model relies on. So it's difficult that way. Is that kind of there? All right. Sorry if I took that in a different direction, but Patrick, anything?
I actually don't have anything to add. I think that's a really good point, that it's hard to separate their kind of free speech, citizenship kind of role that I think they have been. I mean, we have seen these companies, I think, embracing a little bit more of that role lately, both in terms of kind of the things you can't say problem, incitement to violence and a lot of these, ongoing issues, but then also the misinformation, disinformation problem, which I think are kind of two tracks, a little bit separate, though I think overlapping in places too, but that it directly kind of interferes with their financial interest in, kind of, if not fomenting outrage, certainly keeping people on the sites and keeping them engaged. And I think studies have found that outrage certainly drives more clicks and keeps more people on the sites longer. And getting in a flame war in the Twitter in a Twitter thread or on in the Facebook comments is draws a lot of eyeballs and keeps people on the site. So those two things are somewhat at cross purposes. So yeah, I think that's a good point.
And if I can just pick up on that real quick, Patrick, there are also studies that show that falsehoods spread faster than the truth, right? Because oftentimes the truth can be quite boring. Like it's literally what's going on at your local water authority or city councils or something like that. But that is the foundational sort of bedrock of journalism, to try and figure out what's going on in your local community, how decisions are being made in your name, et cetera, et cetera. And unfortunately, or whatever, I mean, it just doesn't draw as many eyeballs as, say, controversies with Kim Kardashian's underwear or whatever. But the only reason I say that is because I just learned we had an alum who went viral on TikTok because she provided a criticism of Kardashian's Skims or whatever they are, saying, so she went viral and she got 7 million some views on her TikTok. So
we'll have her back teaching a class on how to go viral on TikTok next semester. I hope you all sign up.
How to go viral.
I think as communicators, we all want to answer that or have the answer to that question because we get asked it daily. How do you go viral?
Right.
Patrick, I know you responded to April in the chat, but I want to make sure we have a chance to elaborate on her question of how long do you think it will take for the courts to catch up with internet regulation on the state and federal levels?
Slow, very slowly. I mean, the part of the one kind of example of this, just to kind of pluck one from earlier, would be thinking about how the CompuServe case, the Prodigy case that were kind of happening at the same time in the mid 90s. Those cases probably took 3 or 4 years to work their way through the courts. Within a couple of years, then Congress finally gets around to enacting a law that is intended to, in part, sort of solve that problem. And then another few years, it takes another few years for a part of that law to be struck down by the U.S. Supreme Court. And so, it takes a long time. I tend to make the argument that that's not altogether a bad thing. Those of us in the real world would like to see solutions to problems, particularly those that relate to, kind of harmful speech, as quickly as we possibly can. No one should be harmed where undue harm is not, where undue harm is happening. At the same time, particularly when we're messing with things like constitutional amendments and the First Amendment among them, hopefully that should be a slow and deliberative process, and not one that we just sort of, with the sweep of a pen, can sort of change or eliminate or kind of fundamentally alter. So I think that's, I think it's ultimately a good thing that these things take a long time. But in the meantime, again, this sort of culture of freedom of speech, culture of free expression that we have in the country, we do a lot of talking about it. I mean, here we are on a Wednesday night sitting around talking about Section 230 of the Communications Decency Act, and so that means something too, that we sort of, we're actively talking about and thinking about these issues, up to, and so the sort of social change and pressure that can come out of these conversations may, enact change faster and in a more meaningful way than would, a new law or a court ruling in, to one side or another.
The only other thing I'll just add on to that is, and I know that this is not specifically the focus of the conversation, but it's interesting because internet regulation in terms of like speech it takes a while to catch up, but like on the back end, internet infrastructure, et cetera, there are not only national but international organizations that are, establishing, protocols and standards, et cetera, also with their own set of controversies and can be a little slow too, but there's also some interesting stuff going on there too.
Yeah, folks in public relations and advertising know all about the value and sort of strength and power maybe of industry self-regulation, often kind of for the purpose of keeping the government out of, your shop and telling you what you can and can't, sort of how you can and can't do your job.
I have another submitted question to read. Marjorie Taylor Greene commented on Facebook that the fastest way to stop Nancy Pelosi would be a quote bullet in the brain. If someone went out and shot Pelosi and said it was that comment, could she say she wasn't speaking to that person and didn't mean to actually go shoot the speaker? Is there any standing there? Can people make hyperbolic comments about violence and be protected if someone takes them seriously?
Generally speaking, without a sort of direct threat to a direct individual that then that same person who made the threat acts on the threat, it's a tough case to make, which is, so again, like a person who doesn't have an otherwise a connection to the person who made the bullet in the brain comment then goes and acts accordingly, and then sort of lays the blame at the person who made that comment. Again, it would be kind of back to a true threats analysis, which looks at sort of the intent of the threat and the likelihood sort of to actually see that take place. And so I think that, again, you'd have to show something more than a kind of passing connection. I read their comment on Facebook and acted on it, than to sort of find, criminal or civil, for that matter, I guess, liability for the individual that made that statement. I don't know if Ben's got a different thought about that.
Yeah, I mean, it's very interesting because, I mean, in that example, you say that the assailant or whatever would specifically say it was the Congresswoman's words that made me do this. Of course, there are historical examples for exactly this, but what has happened is that the person is charged criminally, and then Congress acts to outlaw other sorts of radicalism or speech or something else. I'm thinking of like back in the early 20th century when the infamous anarchist speaker Emma Goldman gave a speech in Buffalo, New York, and the next day the Polish immigrant Leon Czolgosz went out and assassinated President McKinley and said, I had been to a rally and Emma Goldman told me to do it. Emma Goldman was exiled. I mean, she was imprisoned and exiled with her lover, Alexander Berkman, and others. But in the wake of that event, there were all sorts of laws that were passed to try to prevent that type of speech that would promote, radical anarchism or syndicalism or something else, which would subsequently show up in later Supreme Court cases and may get struck down or whatever. But I'm just trying to think of another example. I think even, wasn't it, I think it was, and I'm blanking on his name now, but John Lennon's assassin also claimed, or had a copy of Catcher in the Rye, right, by J.D. Salinger in his pocket after shooting Lennon. And there was this big uproar about Salinger, but I don't think there was anything brought, against them, because yeah, I don't know. It's very difficult to draw those connections.
Okay, we have about 10 minutes left, so if anybody has any questions, now would be the time to ask it. So welcome further commentary if anybody wants to backtrack to something that was said and just add on to that. I will go ahead and ask the question, what advice would you have for us as communicators when it comes to addressing this with our clients? How can we best advise businesses in the ever-changing landscape?
I mean, it's kind of like the law. It's a little bit fact specific. It would have to, I want to know what clients were specifically concerned about. One thing I would say is that in the Sturm and Drang around exceptions and limitations on Section 230, I think it's helpful to think a little bit about what the purpose of that law originally was, and I think getting a little bit more educated about what precisely it does. It doesn't shield anybody from criminal liability. It doesn't shield any speaker online from civil liability, right? So if I go out and say something defamatory about Ben Birkenbein on Twitter, he can't sue, which I do on a daily basis. You're really walking a thin line here. But Ben is not prevented by Section 230 from suing me for doing that. And so I think where there is certainly room for some reform is and maybe this would be something for clients to kind of think a little bit about, is the ability for people to speak anonymously on any platform that you're using. Kind of how you kind of facilitate speech online that is kind of sort of promoting or prompting people to kind of engage in bad behavior. Of course, anonymous speech is a hallowed part of of First Amendment rights. Going back, of course, to the founding. Where people who had important things to say, but also their lives were on the line for saying them, needed to speak anonymously. And so there's a long tradition historically and socially and legally, I think, around anonymous speech. But at the same time, we also see and get the worst of the worst when we see anonymous speakers. The other problem with, again, back to the Section 230 question is that, if I'm on Twitter under my name, defaming Ben Birkenbein's good name, he can identify and sue me. If I'm doing so anonymously, it might be a little bit harder for him to find me. And so where there may be some kind of room for injustice is where, where anonymous speech is happening online, where it sort of doesn't necessarily need to be happening. So, I mean, I'm not sure if that's a helpful guide for practitioners of public relations, but it's kind of one thing that might relate somewhat to how these platforms are used and how platforms you might have clients who are using might think about.
Yeah, I guess I would, and again, much to Patrick's point, I guess it depends on what kind of clients we're dealing with or anything else, but there are just some general principles that I often try to distill down even for my students. And I'll just say things like, number one, remember that what is legally permissible is not always ethical, right? And to consider the divisions between those two. Just because you can say something doesn't mean you have to say something or you should say something, right? That would be number one. Number two, they often say this thing, well, it's like, that's just like his opinion, and I like respect his opinion. And I say that's false, that's BS, stop it. You don't have to respect another person's opinion if it's wrong or hurtful, right? You can respect a person. People deserve respect, but opinions are supposed to be debated and discussed and worked through, right? Try to understand how this person arrived at that particular opinion, right? And then the third thing I would say is, I don't know, I'm just guessing. I have very little experience, but I'm just reminded of when I was taking initially one of my first First Amendment classes, and they were talking about just online comment sections, or reviews of someone's business or something like that. And the rule there is the Streisand effect, the Barbara Streisand effect, which is that you don't poke the trolls. Like, you don't try to shut down dissent, but you just combat their speech with more speech. So try to add more positivity and stuff, and try to bury them rather than try to go after them and punish them, because that could potentially hurt your reputation. And if you poke the wrong troll, they'll just come after you in waves, and then you just become a target for everybody else. So.
Yeah, I mean, I think both Section 230 of the Communications Decency Act and notably the First Amendment to the U.S. Constitution protect your ability, your right to, play a role in turning down the temperature, where you can and where you want to, online. So I think that's, I think people hopefully can, don't at the very least throw up their hands and say, well, this is all First Amendment protected speech, and so I can't wade in here and moderate or stop this conversation from happening, or indeed encourage other people to kind of weigh in and with better opinions. That's, your ability to do that is actually protected by the First Amendment. So.
Great points. A couple submitted questions. Thank you guys in the chat. From Kristen, what are your thoughts on Facebook's independent oversight board?
I want to hear what Dr. Birkenbein has to say about this, but I also don't want to put you on the spot.
The quotes are doing a lot of work in that question, by the way. I mean, but it's a good point. And I just think that, we've seen the same kind of behavior from Facebook for a long time, which is that and I think that all social media companies are trying to do what they're doing right now in order to resist any sort of calls, which again, there is bipartisan support for, trying to crack into their business model, enforce antitrust regulations, or any other sort of enforcement that the government or wants to bring down on them, for which I do think that there's a compelling argument in certain cases. That's, again, another topic. But I think that they're doing those things to try to self-regulate, to say, no, we'll take care of it ourselves. Just look the other way or whatever, now that we account for 50% of all advertising dollars online or whatever with Google. So I mean, it just depends. For me, I view it more as like a sort of defensive maneuver on their part.
I think it can be both, though. I mean, I think it can be sort of both defensive CYA, try to keep the government off, out of regulating us, and at the same time, a good faith attempt to find a way to kind of moderate on the platform, without sort of silencing too many people or being sort of, an adhocracy about it. And because I think that's, again, back to one of the original questions about, so now that Twitter has set this precedent and then other companies followed about saying, okay, this is where we're drawing the line here and now, it's also a very kind of fact-specific scenario. And so, hopefully we won't be facing incitement to insurrection circumstances over and over again, and having to draw that line or sort of keep drawing that line. Yeah, I mean, so I think it's hopefully, I think it can be also a good faith attempt to sort of draw some common sense boundaries around how policies are drawn up and applied.
Okay, we've got one more question. I think it's a good one to wrap this up for the evening. Do you have any suggestions on resources such as books or podcasts that we can learn more about this topic?
I have a ton. So there's a really good book on Section 230 called The 26 Words That Created the Internet. There's another that relates to, I think, the argument against constitutional absolutism and specifically First Amendment absolutism that has been, I won't vouch for this having not read it myself, but is a good, it has been well reviewed, and a lot of my colleagues are big fans of it, called The Cult of the Constitution. And so those are a couple of books. Podcasts, there's one called Make No Law that is hosted by a First Amendment lawyer and very knowledgeable First Amendment guy named Ken White. There is one that is hosted by the the Foundation for Individual Rights and Education called So to Speak podcast. I like that one in particular because they're very prolific. I think it's a weekly podcast. And so, you know, there's sort of tons and tons of back episodes to go through, and you know, it's interviews, it's topical panel conversations, it's a bunch of stuff along those lines. I'm sure I'm forgetting like a really good one, but I don't know, Birkenbein, if you've got others to offer.
It's so funny because my podcast listening is on different topics. Like I usually try to listen to other stuff.
It's an escape, yeah.
Yeah, so that's a very good question, and I should do better at trying to find some podcasts. And others that have been like very specific. I'm just trying to think of like a general one. You know, there have been particular episodes of podcasts that have focused on one aspect, but if you're looking for something a little bit more general, I'm not exactly sure. I'm trying to remember. I used to, for example, I know that there was a specific episode of the Reply All podcast that dealt with these issues in a number of ways, at least a couple episodes, and it's a good podcast anyways, but I don't know otherwise. And then the issue with recommending books is I'm also trying to find better books, you know, aside from just like the academic books that we read, because I realized that, like, you know, we may enjoy them, but they're often not the most enjoyable reads for other people as well. So I'm always looking for better, just kind of like general, you know, coverage of these issues. But actually, I believe even the New York Times, who's the Adam Liptak, has a good either column or something at the New York Times that discusses a lot of just he's a Supreme Court commentator, and there's a lot of good content there.
Mm-hmm.
Great. Well, thank you very much. That actually brings us right to 7 o'clock, which is our time for the evening. I just wanted to thank both Patrick and Ben for taking time out of their evening to be here. Ben, hope you drive home safe in the snow, and everybody else too. Stay safe, stay warm, and we really appreciate you joining us tonight.
Thanks, everybody. Thanks very much.
I would also say I'm walking home. Second of all, I just remembered this Nobody Speak movie documentary on Netflix, which is also really good. It's about sort of privacy and newsworthiness and the First Amendment and tech. It's very nice. Thank you, by the way. Sorry for that last little addendum.
Thank you, everybody.
Thanks, folks.
Thank you.